Okay, hello guys, nice to see you here. Welcome to the session, rapid revision session on Juvenile Justice Act. I suspect we'll be doing just Juvenile Justice Act because it is a lot to cover, cannot go on stretch for the negotiable acts as well. So we'll try and schedule the NIA portion next. Let's just finish the JJ portion first. So I hope you're doing well. Let me know in the comments how your MP prep is going. You're at the final stages of your preparation. You're not many days away from the exam. You're encouraged to write down in the comments. Yes, guys. So we'll wait just a bit for the other students to join. Meanwhile, again, let me know how your prep is going, if you're having any issues so far. And as I did discuss yesterday in the MP WhatsApp group, any errors you find, any mistakes you think there are, because most often than not, it's just an issue of you getting confused, because I agree the questions are difficult and we are making them in order to get you confused. That is the aim. So I want you to reach out to me. I will discuss it with you. That is a far better manner to get your doubts resolved than to discuss it in the group extensively, where it becomes harder to keep up with who is saying what. So just bring the doubt to me in case there is a doubt that needs to be discussed amongst all students. I'll take it there and make sure everyone has understood the direct intent of the question so that you are better prepared for the examination. All right, we'll be starting in just a few minutes. So by 1:45, we'll start any which way, and the other students can keep on joining. But until then, let's just wait. Let me know who's in the session. You can type up in the comment section, and I'll be able to see. And whether you have taken all your mock tests so far, because those are crucial. See, they not only prepare you in terms of the content, they prepare you in terms of speed. And we know speed is very key in order to pass the examination. If you fail at answering all the questions, you'll just feel a lot worse. You just have to be able to time yourself and answer the questions in A, the time constraint, and B, the pressure. So whenever you're taking your mocks, imagine that this is the examination hall and you're taking your actual prelims. There's that pressure, and I want you to know, because that is why we create this simulated environment. I want you to become friends with that pressure and become friends with that time constraint so that you can perform at your absolute best in the prelims examination. So we are just a minute away from starting. We will be discussing the JJ Act 2015 today. So how are we feeling? You must all have taken your JJ Act mock by now. So I'm hoping you'll know most of the things we'll discuss here. And if you don't, that's okay. You still have a bit of time to recapitulate on the concepts and become better. All right, guys. So we'll be starting now. So let me present, and once I present, please do let me know if you can see the whiteboard right here. Are you able to see the whiteboard, guys? If at any point you cannot, Vikas, please let me know because I'm not able to see the comments right now. So, guys, we'll be discussing the JJA, the Juvenile Justice Act. The proper title of the act is the Juvenile Justice Care and Protection of Children Act of 2015. Now, right, we know that this is an act that pertains to children, but who exactly, what part of children, what classification of children does it pertain to? The term juvenile, when we look at the proper definition, the term juvenile is representative of a person below the age of 18 years. Okay, so that is a juvenile. Before we delve into the rapid revision session of JJ Act, we must bear in mind the certain situations that created the need for the JJ Act. There was a social upheaval, if you remember correctly, in the period from 2013 to 2015, right? There were a lot of sex offender cases, there were a lot of scandals, and a lot of social issues that deep down disturb the core and the fabric of the society. So the 2015 Act itself, we know that the Nirbhaya case, most predominantly, the Nirbhaya case and the social upheaval that happened, the unrest that commenced because of it, created a widespread change in many criminal laws. And we saw changes in IPC, CRPC, etc. And the same need was felt in the JJ Act as well. So we can contribute the revamping of the Act and the creation of the Act into the 2015 Act to such social events, right? So the Nirbhaya case, etc., we know that in the Nirbhaya case, a juvenile, a 16-year-old at that time, was involved, right? So this case created, again, this case and other events also, not this case in isolation, created a need to redefine what was meant by a juvenile, to redefine what was meant by protection to a juvenile, right? To redefine and demarcate how juveniles were to be treated. And was this treatment to be equal to or unequal to the treatment given to adult convicts or adult people, right? If they are in conflict with law. And it also explored what must be improved in the current juvenile justice system, what must be reformed in the current juvenile justice system. So we saw that there was a need to reevaluate everything that was done so far, right? Just give me a moment to erase this. I hope you're following through so far. This was just the basic. We were building up the base for our understanding of the JJ Act. All right, now. So, of course, we know that the JJ Act did not come up out of thin air. There was a wide genesis to the JJ Act, and it was based both in the British era and then in the independent Indian era. So, let's see what existed in the British era, right? So, this is the British era. First of all, now we must remember that this is not exactly the JJ Act, but acts that laid the basis for what is now the JJ Act. There's always a genesis of things. We understand, why do we study constitutional history? To understand where all the elements of the present constitution came from. There was the Apprentices Act of 1850. That was the first stepping stone. There was the Whipping Act of 1864, right? Then we deal with the Indian portion, the independent Indian era. Let's call this the Indian law era. We had the JJ Act of 1986, right? We had the JJ Act of 2000, right? Which to which we had the addition of JJA Act 2006 and 2010 amendments. And then finally, a bigger act that came into being, the biggest in question, a consolidatory and a final act, the Juvenile Justice Act 2015, which we are currently dealing with and which we will be currently discussing. I hope it's all clear up until now and quite easy to follow. Right? So that was the basic genesis of everything, why it happened, where it came from, where the current act came from, and what were the general social situations in respect of the current act. Let's understand a bit about the international commitments. Of course, behind every act, there's either a social upheaval and a social cry that you have to satisfy. There's always a social need. And apart from that, there are international commitments and a broader international need for the country to follow. So there are several international commitments for the country to keep pace of. Let's remember that on 11 December of 1992, the government acceded to the convention. We must all know this by now, the Convention on the Rights of the Child. Right? We know that it was adopted by the General Assembly, and the basis behind it was to protect the rights of the child, rights of the children, and uphold everything in the interest of the right of children. So the Indian nation has to live up to this, which it has ratified, it has acceded to, sorry. Then it also has to live up to the UN standard minimum rules for the administration of juvenile justice. This is 1985. These are also known as the Beijing rules. Right? Then there's also the UN rules for the protection of juveniles deprived of their liberty. This is 1990. There is the Hague Convention, of course, on protection of children and cooperation in respect of inter-country adoption. This is 1993, right? So a variety of international instruments that the country has to uphold and the country is inspired by in upholding and in implementing the JJ Act. So we have to bear in mind that all these things have an element, have a role to play in the creation of the JJ Act. And we'll see resemblances, we'll see the country in its attempts, we'll see the legislature in its attempts to redefining and amending and strengthening the JJ Act. We'll see it satisfying the broader perspective of all of these rules and making leaps forward in redefining and advancing the act, right? Now, we know that around, we'll come back to the act now, as we understand the broad basis behind it, we know that around the 2015 time, there was the Justice Verma Committee instituted after the Delhi gang rape case. Justice Verma Committee formed in 2013, and in its attempts, it gave many of recommendations. One of its recommendations was that the term juvenile The term juvenile should be referred to a person who is accused. So the key terms of accused of a heinous crime, but is under the age of 16 years. Right? So that is what they said. And that if anyone who does this, who fulfills these elements, is accused of a heinous crime, but is above the age of 16, he shall not be subject to the JJ Act. He should be treated as an adult and put in an adult courtroom, right? But then we saw there was intense controversy, there was intense debate, etc. And we saw the replacement of the 2000 Act with the 2015 Act, right? Where juveniles in conflict with law in the age group of 16 through 18 years of age involved in heinous crimes were covered by the Juvenile Act as well, right? So that was the basics leading up to the JJ Act. Let's start picking apart the Act now. So the JJ Act, if at any point you have questions, please raise them. You're encouraged to do so. Vikas, please help out in moderating the comments just a bit and inform me. So the JJ Act 2015, when was it enacted? It was enacted 31st December of 2015. That is the enactment date. Question that often appears. The enforcement date, however, is 15th January of 2016. Enforcement, right? The Act itself is divided into 10 chapters and 112 sections. All right, so that is the blueprint of the Act. What are the objectives of the JJ Act? Of course, we understood, again, the benefit of understanding the basics of the Act. The backdrop of the Act is that we'll get to know the objectives. Again, the objectives are to fulfill all of these things: the fulfillment of interest, best interest of child, protection of children, so on and so forth, right? So let's note them down just a bit. The first objective of the Act is the consolidation of and the amendment of laws which relate to children who are in conflict with law. Two terms we'll see appear many, many times in the JJ Act: conflict in law and children who are in need of care and protection. All right, then it caters to the basic needs of children in conflict with law. We'll call them CWL, children in conflict with law. It caters to their basic needs by protecting them, caring for them, giving them development, giving them good treatment that helps them recover from whatever happened, and helping them socially reintegrate. That's another objective. The other objective is, see, the juvenile justice system is set apart from the general justice system. Why? Because the general justice system is aimed for adults. Children, juveniles need a specific type of care and a specific kind of dealing with them, even when they're in conflict with law. So the objective of the Juvenile Justice Act is to adopt a child-friendly approach in adjudication of matters. Of course, law owes a decency to every person. Everyone is presumed to be innocent until proven guilty. But this decency turns into a child-friendly approach, an even softer approach when dealing with juveniles, considering their special age, considering the tenderness of their age and the tenderness of their mental capacities. We don't want to scar them as a society forever. So we want to deal with them softly and make sure they're able to become socially reintegrated into the society, right? So a child-friendly approach is adopted in adjudication, in disputing, in disposing of the disputes that come to the courts. Then the other objective is to establish adequate authorities. Of course, if you are setting apart the situations, if you are setting apart the provisions, if you're setting apart the procedures, you need to find a specific authority. So an adequate authority is created to deal with all of these matters in the above discussed manner, right? And then another objective is to make sure that the needs, basic needs of children are met, the basic human rights are protected, right? Basic human rights, whether they are internationally obligatory for the state to enforce and protect and ensure, and whether they are in the Constitution of India as the fundamental rights, etc. Right? So, this is the objective. Now, let's start to deal with the Act section by section. We won't be able to discuss all 112 sections, but I have picked a large array of the most important sections that will appear and may appear and most likely to appear in your examinations, and also otherwise sections you must know, from your general preparation point of view. Even if they don't appear in your prelims this time around, you must know these. So, starting with section 1, of course, section 1 gives you a short title, the extent, the commencement of the act, and it states that the full title of the act, as we started off with, is the Juvenile Justice, Care and Protection Act of 2015. And at that point of time in 2015, it was not applicable to J&K, but after the reorganization of the act, except for the state of J&K, was repealed, and it is now applicable on whole of India. Right? Then the applicability of act, right? So 1.4, the applicability of act. So we have dealt with extent, we have dealt with title. The applicability of act. Section 1.4 states that notwithstanding anything contained in any other law, the JJ Act 2015 shall be applicable to all matters concerning children hyphen. Now, which children? Children in need of care and protection, children in conflict with law, right? Including, it uses the word including, apprehension, detention, prosecution, penalty, imprisonment, rehabilitation, social integration. So, all these things I've been talking about so far of children in conflict with law. Then also procedures, decisions in relation to, orders in relation to the same rehabilitation, reintegration, restoration of children in need of care and protection. Like I said, two phrases you'll see replicated very, very often: care and protection and children in conflict with law, right? So it makes sure that all the matters concerning these children, right, who are in need of care and protection and children in conflict with law, where even if it extends to apprehension, detention, everything, all of these aspects of the legal system, of the justice system, everything is covered in the JJ Act. Apart from this, a very significant thing that the JJ Act does is that it creates a soft classification of the offenses. So we see offenses being divided into, just a moment, let me raise this. So we see offenses being divided into heinous, serious, and petty offenses, right? And we see section 2 talk about it later on. But generally, we'll understand that offenses which are petty in nature, they have a maximum imprisonment of up to, or we can say they are less than 3 years of imprisonment in the IPC. Those are petty offenses. When it comes to serious offenses, the imprisonment of which is between 3 through 7 years for IPC, right? And then serious offenses, the offenses for which the minimum period, right? The minimum period is, just wait a moment, this should be the other way around. Petty is less than 3, and here heinous is over 7 years. That is, the minimum period is 7. Here, the maximum period is 3, right? 7 years of imprisonment per the IPC or any other law. These are heinous. So anything with the imprisonment going further than 7 years is heinous. Imprisonment between 3 and 7 years is serious, and imprisonment up to 3 years will be considered petty, as under the JJ Act. And this classification is important in understanding the provisions of JJ Act. All right. Now, moving on to section 2, that is definitions. We have a lot to cover, so let's pick up the pace now. I hope you've understood everything so far. So, first of all, section 2, as always, dealing with definitions. 212, it has many, around 70 something. So, let's just cherry pick the ones that we need. 217 is defining child. Who is a child? A child is a person who has not completed 18 years of age. All right. 213. Who is a child in conflict with law? Something we have been talking about so far. Child in conflict with law means a child who is alleged or found to have committed an offense, and this child has not completed the age of 18 years on the date of committing such offense. That, students, is a child in conflict with law. Next, we move on to the definition of 214, giving us the definition of the other thing we were talking about. One, child in conflict with law. The other was child in need of care and protection. Now, who does the JJ Act see as a child in need of care and protection? So, this is a bit long-winded, but we'll just breeze through it. A child in need of care and protection is either a child who does have a home, doesn't have a home or settled place of abode. That means a place to go to, a place to live, basically, and is devoid of ostensible means of substance. So a child who pretty much has nothing, right? A child who does not have a safe space to go to. Of course, he's a child, so he won't have any means of subsistence, right? Or classification number 2, a child who does live with another person, right? Resides with a person, but unfortunately, this person that he lives with is injuring him, abusing him, violating him, neglecting him, and neglecting the laws which are imposed upon him in interest of caring for the child, right? In interest of protecting the child. Or even if this person is threatening to do any of this, even if the person is threatening to injure, to exploit, to abuse, or to kill this person, right? And this child is fearful that this thing can manifest as a true thing, right? There's a reasonable likelihood of this threat actually manifesting into an actual event. That also becomes a child. That child immediately becomes a child in need of care and protection per the JJ Act. Or if this child is residing with a person who abuses, exploits, neglects, or kills some other child or children, not the child he's living with, but other child. So if the child is residing with a person who is habitually abducting other children, abusing other children, then again the child immediately in his care is not in safety and considered to be a child in need of care and protection under the JJ Act. Or another classification for the child in care or need of care and protection, like I said, it's a bit long-winded to understand, but the definition is made kind of exhaustive here. So another is a child who is mentally ill or mentally or physically challenged, right? Or suffers from incurable or terminal disease, but does not have any support. There is no support for this child. So the boards, the authorities that are designated to look into this matter, they find out that they have there is no support for this child, then this child becomes a child in need of care and protection. Again, a child who has parents, now we come on to the parents bit, parents or guardians, who has parents or guardians, but they are incapacitated or unfit. And this is a finding of the authorities. The authorities under this act are the Justice JJ Board or the Child Welfare Committee, the incapacitated or unfit to look after the child's well being, right, or safety, or a child who is abandoned or surrendered. We'll understand what these terms mean. And of course, has then no parents, no one to take care of him, or a child who is missing, or a child who has run away, and this child's parents are nowhere to be found. Parents cannot be found. Okay, or a child who has been or is likely to be abused, tortured, exploited for immoral purposes or illegal purposes. That child also needs protection and care, and the JJ Act acknowledges that. Or a child who is found vulnerable or has been inducted into drug abuse or trafficking. And there is another kind of issue involved. The children can fall victim to children without people to care for them. That is a child who is likely to be abused for unconscionable gains, right? So the other residual evils of society. Or a child who is in a situation where he is a victim of armed conflict. So armed conflict, civil unrest, or it does not always have to result from other people. There can also be situations such as a natural calamity. So natural calamity. So there are floods, or there are landslides, floods, very unforeseen situations where the child is left behind, does not have anyone else, etc. So that is also child in need of protection. And lastly, the worst social evil, which is a child who is in imminent risk of marriage while he is still a child, right? And here, the child's parents, the guardians, family members, they are likely to be responsible for the solemnization of that marriage. But while that happens, the child is in need of care and protection. So that was the big definition of a child in need of care and protection. We have covered child in conflict with law. We have covered who a child is. Let's move on to who an officer is, that is 270. Now these are important definitions. There are a lot of definitions, all are very crucial. These ones are cherry picked by me because they're extremely important and frequent a lot in your examination. So pay attention to what the definition says as well as the subsection that deals with the definition, which is why I'm writing all of it down. Officer. Who is an officer per the JJ Act? An officer is attached to a child care institution. A child care institution that is carrying out the directions of the JJ board or the Child Welfare Committee, right? And he is known as a Child Welfare Officer, right? That is a officer 218, 217. 218 then discusses what a children's home will be. Now, a few definitions about these bodies. They briefly define them, then say these things are established under the so and so section of the Act. So bear in mind that such sections are discussed later in the chapters of GJ, but this is the exact definition given. 219. 219 is for children's home. A children's home is established for the purposes mentioned in section 50 of the JJ Act, right? It is established and maintained by the state government, and it does so in every district or group of districts, either by itself. The state government does it either by itself or through an NGO. So you'll see tie-ups of the NGO and the state government in creating children's homes, right? 220 tells us what a special court is. A special court is a court especially trying the cases that involve children. That is a special court. It is established under the following. It is established under the ambit of commissions for protection of child rights Act 2005 and also under the POCSO Act 2012. Right? So, in an absence of these courts being designated, what happens if these courts are not designated? In an absence of these courts being designated, the Sessions Court will have the jurisdiction to try these. But otherwise, these special courts stand there in place of the Sessions Court. Now we move on to 222. Moving on to section number 222. All right. 222, talking about a child welfare committee. A child welfare committee is constituted under section number 27 of the JJ Act. That is what 222 says about the child welfare committee. Then 224, it is telling us what corporal punishment is. Another important thing discussed in the JJ Act, corporal punishment is defined to be any kind of physical punishment, right? Where you inflict physical harm, physical pain deliberately on a child with the aim of retribution for an offense. So, even if you're a person in possession of a police officer or whatever, you cannot, with the aim of retribution for an offense, subject a child to corporal punishment. Or even if a child has committed an offense against you, you cannot subject that child to retributive punishment, that is corporal punishment. That is prohibited under the JJ Act, of course. And also, for if you are inflicting corporal punishment for disciplining or reforming the child. So if you're a teacher, if you're a guardian, if you're a caretaker, if you're an older cousin, whoever in the family, you cannot use corporal punishment. If you are putting the child under physical pain or harm with this aim that I'm trying to discipline or reform the child, you are exercising corporal punishment. 231 up next. 231 is telling us about who a guardian is. A guardian may or may not be related to the child, but he is in fact in actual charge of the child. Now, who is this guardian? He is a person who is recognized by the Child Welfare Committee or the Juvenile Justice Board as a guardian in its proceedings. So it completely sits down in proceedings, determines whether the person is fit for being a guardian. If they find him fit to be a guardian, he is a guardian. So it's not necessary that he is related to the child. It is necessary that the court finds him fit to be a guardian and then he remains in actual charge of the child. Next important definition is 233, and we discussed this already. This is heinous offenses, right? Defined as offenses which are very serious and hugely or largely affect the society. And what we know already is that the imprisonment is 7 years and above. All right. Now, the most pressing definition, juvenile. Juvenile defined in 235 of JJ Act, any child who is below 18 years of age. Okay. Next up, 240. What is an observation home? Many institutions created under the JJ Act, and this is one of such. Observation home is established for the purposes mentioned under section 47(1) of the JJ Act. Again, it is established by state government, just like we discussed earlier. State government, and in every district or group of districts, right? Either by itself or through an NGO. So the same thing we discussed a few subsections over. 241 is telling us about what an open shelter is. This is because, see, you have to remember which section. You can create mnemonics or whatever. You have to remember which section discusses this. There will be questions that ask you which section of the JJ Act defines what an open shelter is. Open shelter is defined in 241, defined as a facility established for children for the purposes mentioned under section number 43 of the JJ Act. Again, the same story, established by state government in each district or group of districts, either by itself or through an NGO. Next up, an orphan. Who is defined to be an orphan under the JJ Act? This is up in 242. An orphan. An orphan is a child who is without his parents. Right? So if we see an orphan child is defined under the JJ Act as a person who is without his biological or adoptive parents or legal guardian. But the JJ Act does not stop there. It states that an orphan is either this child or a child whose legal guardian is unwilling or incapable of taking care of the child. Clear up until now? So that is also considered to be an orphan, such a child. We move on to 245. 245 telling us about petty offenses. We discussed these again. Less serious nature, up to 3 years of imprisonment. 254 is telling us about serious offenses. Okay, now this one was added in 2022 September, the definition 254. Let's remember that. So again, these are of serious nature, affect the society as well, but they can have punishment ranging between 3 to 7 years, right? Then we have 260 talking about who a surrendered child is. Remember, we saw this as a child who might need care or protection. A surrendered child is defined as a relinquished child. Relinquished means it's handed over. Relinquished child, who hands him over? Who relinquishes him? The guardian or the parent? And who is this relinquishment done to? The relinquishment is done to the Child Welfare Committee. Why? Because there are emotional, social, or economic physical, emotional, or social factors that are beyond the control of the guardian or parent, and such a child is surrendered. This guardian or parent is highly incapable, and it is impractical and impossible at a point of time for them to take care of this child, and thus they surrender or relinquish the child to the Child Welfare Committee, and they become a surrendered child. Now that was all of your definitions. We will move on to chapter 2 next. Is everything clear so far? Please let me see some comments. Just a moment, I'll try and see. Vikas has not updated me of any comments, so I'm presuming there are none. Any comments, anything you want to discuss, guys? Because we need to move on to chapter number 2 now.
Discuss, guys.
Yeah, see, Abhay, juvenile, and child are two different terminologies. They are similar, but they're not mutually exclusive, right? We are discussing with the juvenile over here. They are similar for some purposes. The word child can be something else. But once we see a child, it's just a subset. Child, and then juvenile can be thought of to be a legal subset of the word child, right? I hope that answers your question. Any other queries, anything you want to say before we proceed to chapter 2, guys? All right. Okay, then I'll move on to chapter number 2. Okay. So, chapter number 2 just gives us a basic view of what the general directions are. So, chapter 2, there are general directions in here, general principles more aptly. There are general principles in here that the JJ Act needs to follow in administering the act, that the authorities need to follow in administering the act. Now, who are the relevant bodies here that need to enforce these? This is the central government, there is the state government. These are directions for the child welfare committees. These are directions for the JJ board, the Juvenile Justice Board, and other agencies that are created under the Act. This is a basic guideline chapter for all of these agencies to follow. All right. Let's continue. So now section 3 is what we will be dealing with here. And section 3 gives you these principles. I'll be naming and briefly describing these principles. There are many, many of them. The first principle is the principle of presumption of innocence. Now, any body in contact with any, administrative body, any constitutional body, any legislative body, in contact with the children, any judicial body in contact with the children has to presume the innocence of the child involved. So up to the age of 18, a juvenile must be deemed innocent of any malified or illegal intent, right? It's taken into consideration from the very inception, that is to the end, right? So this is during trial. During the procedure of trial, there should be a presumption of innocence on part of the juvenile. This should operate automatically. That is the first principle that is to be followed. That doesn't mean that even if the juvenile is held to be in conflict with law, you consider them innocent, but you have to presume that they are innocent until that time comes. Then there is the principle of dignity and worth, a very widely recognized international principle. Dignity and worth, that all human beings are born equal and dignity and worth, born free with the same dignity, with the same rights. They should be held and had with equal rights and dignity, right? So applies to the juveniles involved here as well. So you should not be stigmatizing them, you should not be labeling them, you should not be discriminating against them. You should be taking care of them, respecting their personal identification, respecting their relevant matters. Next is the principle of best interest. Again, a very uh, a thing that is at the core and the basis of the JJ Act. So all the decisions that happen by the authorities, by the judicial bodies constituted under this Act, everything that happens must be done keeping in mind the best interests of the child presently and also in light of his future. So, what is the best interest of the child for his present? What is the best interest of the child for his future? Because he does have a future to live up to. So, you will have to consider their emotional, their intellectual facilities and demands, their physiological demands, their psychological growth, and everything. Because these are all things that are yet to set, they're not yet adults. For adults, this has said that the cognitive patterns have set, the mental patterns have set, the habits have set, but for a juvenile this is yet to consolidate and solidify in their minds, which is why you have to keep their best interests at heart and at mind when adjudicating on their cases. This is another principle that is to be observed by all the bodies under the JJ Act. Then there is the principle of family responsibility, right? So any body under the JJ Act that comes in contact with the child has to work together with the family of the children who are in conflict with law. There has to be an active participation of whether it is guardians, whether it is the parent. Now, if it is a surrendered child, etc., that's another story. But generally, the family responsibility has to come in, and the authorities have to make sure that this caretaker, this guardian, this person is actively present there. Then there is the principle of safety. Of course, you have to make sure that the child is safe and sound. There is the principle of positive measures. You have to take positive measures. So that means you have to exercise resources that promote the well-being of the child, that keep the child's interests, active, that keep the child's identity developed. You have to develop the child's identity, that create an enabling environment. So all in all, a very uplifting environment for the child by use of positive measures. You have to observe the principle of non-stigmatizing semantics. Let me write that down a lot more clearer. Sorry, guys. Non-stigmatizing semantics. So semantics simply refers to terms and labels that you're putting, and stigmatizing is something that creates a mental image that is not good, a stigma. Non-stigmatizing is the opposite of it. So you have to use words that don't create a bad impact in their mind. You don't have to refer to them as criminals. You don't have to refer to them as degenerates. You don't have to use these terms. You have to use good semantics. You don't have to refer to them if you're a person in conflict with law and you're being treated in front of the JJ board, you're in front of the child welfare committee. The committee must not refer to you as an outcast or use terms that are harsh and that might impact your emotional well-being and your intellectual facilities, right? So they must use non-stigmatizing terms or semantics. Next principle is very important: non-waiver of rights. So we know that the Constitution, our rights, whether they are fundamental or however, they are not to be waived off. You cannot say, no, I am waiving off my right to life. I don't want to live, right? So the principle of non-waiver of rights is of furthermore importance with respect to juveniles, right? So they have a right to be represented, they have a right to be kept safe, right? They have a right to be kept secure, they have a right to be kept in nurturing and uplifting circumstances, as we saw in the positive measures portion. So this should be absolutely non-negotiable. There is a non-waiver policy on all of these rights. That is an important principle that you have to follow. Even if the child does not want to stay safe, there is a child who must be, there can be children who are, like we saw, a child in need of protection can be a child who was abused for sexual purposes, a child who was used who was subjected to psychotropic substances, to narcotics. So such a child must and might need, might find the need for drugs, further drugs, further psychotropic substances. Do you allow the child to use that because the child wants it and he wants to waive off his right to be protected? No, there is a strict non-waiver of rights. The child must be protected. Then the principle of equality and non-discrimination. A juvenile comes to the legal system, comes to the juvenile justice system, no matter where the child is from, he's equal, cannot be discriminated against. The principle of right to privacy and confidentiality, another important principle. The children have a whole future, they have their entire lives to live up to, in the future after they come out of the system. So anything, if you're stigmatizing them, if you're labeling them, if you're bothering and compromising their privacy, it will have long lasting effects on their future. It will have long lasting effects on their personal lives, on their marriages tomorrow, on their children tomorrow. First of all, on their employability, right? So their privacy needs to remain key. Then the principle of institutionalization, institutionalization as a last resort, right? So institutionalization, to put them in, shelters, open shelters, or there are open air prisons, sort of, but we don't call them prisons in the JJ Act. So the institutionalization, the commitment of these juvenile institutions must be treated as a last resort, and every possible resource must be exhausted up until then. So you want to safeguard the child's respect, you want to safeguard the child's right to growth, you don't want to deprive the child of their liberty, right? You don't want to detain them, you don't want to incarcerate them. These things should be used as a last resort, absolutely. Then there is the principle of repatriation, that is, they need to be returned to their family, and restoration. Any social circle they were in, anything that they were exercising prior to, you have to attempt, the authorities that the guidelines are for here, the directions and principles are for here, which we discussed, the state government, central government, the board, the child welfare committee, and any other authorities that are created, they have to make sure that any and all attempts are being made to restore the child to the original position before he came in conflict with law, or before he was in a state where he needed protection or care. Then there is the principle of fresh start. You have to give the child a fresh start. So you have to make attempts to have the child get over anything that happened, and so that they have the full capability to give things a fresh start. There is the principle of diversion. Again, diversion, a point that was raised when I told you a new set of authorities need to be created for JJ Act that can fulfill the purposes of the JJ Act. Generally, the legal system can appear to be very rigid, difficult, sluggish, or indifferent. The authorities involved have to make any diversion, legal diversions possible. So if they can do anything to speed up the process of JJ proceedings, they can do anything to speed up the process and make sure the child's best interest is being made, it has to take that diversion in the interest of doing it, right? So you have to make sure you're encouraging those processes. And then finally, the principle of natural justice also needs to be observed. So that is all about section 3 and all the guidelines it imposes upon all the authorities involved. Are we clear on the principles here? Yes, guys? Let me pull up the comments. All clear on these guidelines? Shall we move on to chapter number 3 now? Perfect, Abhay. So we'll move to chapter 3. Okay. See, now we know that generally the juveniles are until 18, right? But as we saw the Justice Verma Committee recommendation as well, actually the Juvenile Justice Board gets to decide for a specific set of children, that is children between 16 and 18. It examines the situations and it gets to decide whether they should be tried as adults or not. Okay, so this is also something covered in this chapter, right? So the Juvenile Justice Board itself, let's see what it states. So we go through chapter number 3 and we see there are provisions for the constitution of the Juvenile Justice Board. Let's see, that would be section number 4, right? So the constitution of the board and the composition of the board. Of course, the state government constitutes it. Again, for it can have one or more juvenile justice board for each district. So that is the level of distribution of juvenile justice boards, right? So, and in each district, this juvenile justice board is created keeping in view the aim of schedule number 7 of the constitution. which the schedule states, as we know, there must be administration of criminal justice by the state government. So the state government in creating these JJ boards is exercising the right and the view under schedule number 7 of the constitution, which makes administration of criminal justice a state matter. All right. Now, what is the composition of the board? First of all, we require metropolitan magistrate or just a moment, metropolitan magistrate or a judicial magistrate first class. That's a person required. There are two social workers, of whom one is to be a woman. Okay, this is a JJ board basically. What is the experience required for them? What is the experience required for these two social workers? The experience here is 3 years of special knowledge with respect to child psychology or child welfare, right? Because there are many nuances to this. You cannot pick any metropolitan magistrate, any judicial magistrate first class who was earlier dealing with white collar offenses and place them in a juvenile justice board. No, they must have a special, view of the psyche of a child and what is required of a child, what happens in a child's mind, and how their interests can be best secured. Then the experience required here for these social workers is 7 years in either education or health or welfare activities which relate to children, or they can have a degree in psychiatry, child psychology, or sociology, or law. So you see, all these areas have something to lend to the welfare of a child. You always learn something about children in all of these areas, right? So if it is education, you learn about children. If there is health or welfare activities regarding children, of course you'll learn about children. In psychiatry, psychology, and everything else, you learn about children as well. So here there is a case law that I find pertinent to discuss. That is the case of Himachal Pradesh versus Happy. This is a case of 2019. The citation is HB 700. There you go. And here, a judgment was passed by a single member. We saw that there are 3 members required in a JJ board, right? The 2 social workers and then the metropolitan magistrate or the first class magistrate judicial. And only a single member passed a judgment without following the necessary functioning of the JJ board, right? So the composition was not complete, and the high court held the judgment as void ab initio, right? So this is highlighting the importance of the composition and constitution of the JJ board. Then we have the case of Sant Das versus State of UP. This is in 2003, and this is the citation 3242, and it is the Allahabad High Court, where it stated that where the Juvenile Justice Board is not constituted, what happens? The magistrate will have the jurisdiction to deal with such matters, and then the appeal can go to a sessions court, right? So we need the Juvenile Justice Board to be constituted. We need it to function properly, and where it is not constituted, this case eliminated on that situation. So that is about the proper constitution and the functioning of the Juvenile Justice Board. Now, we read about what the members need to be eligible, what their experiences are. Let's see as what happens to be a non-negotiable position for a member of a juvenile justice board. So what operates as a non-eligibility, right? So what member is not eligible? This is dealt with in 4 subsection 4. If it is a member who has a past record of violation of human rights or children's rights, okay, if it is a person who has been previously convicted of offense involving moral turpitude, right, but this conviction should not have been reversed, right, or he should not have been given full pardon. If he has been given full pardon, it won't operate as a conviction for moral turpitude. So if he has been convicted and he stays convicted and he uh, lives out his conviction, whatever the punishment was. If a person has been removed or dismissed from central or state government services, or from the services of an undertaking that is owned or controlled by the state government, etc., again, also he will, because the removal or disqualification or dismissal grounds, they definitely have something to say about the person, and such a person cannot be entrusted in a JJ board. Also, if the person indulges in something such as child abuse, immoral acts, employment of child labor, of course, or any other violation of basic human rights, that person cannot be a member found to be eligible for this post. 4.6 further on deals with the term of office and manner of resignation of the members of the board. Then we have 4.7, which deals with termination, right? This dealt with term and manner of resignation. This is dealing with termination. So the terminations only happen after proper inquiries take place, right? And the inquiry, of course, the appointing body was the state government, so the inquiring body will also be the state government, right? But this, it's important to notice that 4.7 is not applicable to principal magistrate, right? Apart from this, a person can be terminated from being a member of the JJ board if, of course, there's an inquiry, if the person is found guilty of misusing the powers vested under the JJ Act, if the person fails to attend the board meetings consecutively for 3 months without any valid notice or reason, if the person fails to attend at least three-fourths of the sittings in a year, or if the person becomes ineligible for his term as a member. And and then apart from this, the tenure of the board is 3 years, right? And the appointment of the members, of course, the tenure is 3 years, so every 3 years everyone is kind of, the appointments are flushed out, new people are brought in. And then a social worker, being a member of the board, is eligible to appointment for a maximum of 2 consecutive terms. So if you're doing very well, you can give up to 2 consecutive terms over there. All right. Next, we move on to section number 16. Section number 6. Quickly. So, section 6. Section 6 lists out 3 important points when you are dealing with juveniles, so under 18-year-olds, at the time of commission of an offense, right? So, what is the first point? The first point states that a person who has completed the year of 18 years at commission, right? So a person who has completed the age of 18 years at present, but he was under 18 at commission. What happens? So presently the child is above 18, but when he committed the offense, he was under 18. He will still be treated as a child during the inquiry. That is point 1 made by section 6, right? If a person is not released on bail by the JJ board, if the person, because now he is above 18, right? If he is not released on bail, he will be placed in safe, the place of safety during the inquiry. That is another good point that section 6 makes, right? And then it also lays out procedures to deal with the child. What child? He is presently over 18, but he will be treated as a child because he committed the offense at under 18 years of age, right? That was section 6. Let's move on to section number 8. So that's the key information. That's a question that features. You get situation based question on this uh, pattern, that so and so person was 17 years and some months old when he committed an offense. Now he's 18. What happens? So section 6 kicks in there. We have section 8 moving on. Section 8 of JJ Act contains procedures, right? So first it states that the board has exclusive powers. The board, we know, constituted under section 4, and it has exclusive powers to deal with all the judicial proceedings that happen with children in conflict with law, right? And it's important to notice that the powers of the board that are under all of these, they may also be exercised by the High Court and the Children's Court when it comes to, powers such as appeals, revision, etc. Right? So Section 8 deals with that. Then Section 8 also tells us about the functions and responsibilities of the JJ board. Of course, these functions and responsibilities are to make sure that the child, his parents, his guardians are well informed about all the processes that happen, make sure that they are participating in the processes that happen, make sure that the child's rights are ensured. Where the I'm sorry, just a moment, there's an earthquake. I'll have to briefly pause. Okay, I think it just maybe got better. So sorry for that. All right. So the functions and responsibilities we were talking about, it has to make sure the child's rights and everything are ensured and protected while the child is being arrested, when there is inquiry, whether there is aftercare proceedings happening, rehabilitation proceedings happening, also making sure that there are legal aids available to the child, right? And if the children, of course, might sometimes need additional information, they may need to be pacified quite a bit. So there is a person who can help them. That can be the need of translators, interpreters. So there are those available. And of course, there's another important provision that the probation officers or the social worker, etc., who is allotted to the child, they do a social investigation and submit their report within 15 days from the date of first producing the case to the Juvenile Justice Board. 15 days time, right? So that you understand the entire circumstances immediately, as quick as possible, in which the offense was committed. And then, of course, the adjudication and disposition is done with respect to what is provided under the act, which is section 14 tells us that there is a time limit within which the cases should be winded up. And then if there is a child who is in need of care and protection, the board will then direct that child to the child welfare committee. So the children in need of care and protection go here. Basically, this is an important thing to understand. And the children in conflict with law go to the Juvenile Justice Board. These two wings handle most of everything. Next, it also needs to pass the final orders, etc., make the disposition of the case, and create a plan for rehabilitating the child. So, a long term plan to create declare whether a person is fit to take care of the child after the proceedings are done, the inquiry is done. So the person the child is being handed over to, is that person fit? So again, a responsibility for the board. And then of course it is also tasked with conducting monthly inspections of the facilities in which the child will be kept and staying, so that it makes sure that the child is in good hands. And it also has to order the police for registration of FIR of offences, right? Written complaints, and it has to make inspection of jails, um, inspection of the holding facilities where the children are found, and it has to inspect jails also, to make sure that no children are kept in jails, right? So if a child is kept in jail, it has to make provisions for the transfer of that child that was found in a jail, and also to perform any other function that it deems necessary for realizing this act. So that was section number 8, describing the brief functions and responsibilities of the Juvenile Justice Board. So highlighting the importance of the justice boards, stance and stature in juvenile, issues, and issues where juveniles are in conflict with law or whatever. The Supreme Court has stated, in the case of exploitation of children in orphanages in the state of Tamil Nadu versus Union of India and others. This was a writ petition 102 of 2007. The Supreme Court has written down that the juvenile justice boards in these matters should not be silent spectators, right? So it has expanded further the ambit to which the Juvenile Justice Board must strive. And also in the case of Puneet S. versus State of Karnataka, the Karnataka High Court has held that the JJ board has the power to decide whether an offense committed was heinous or not. So, giving interpretative powers to the Juvenile Justice Board. And I hope that briefly recounted whatever the Juvenile Justice Board is required and obligated to obliged to do for the JJ Act. Now we move on to Section 9. Section 9 does briefly tell us that there is a possibility. So if there is a magistrate who has a certain opinion about a juvenile case, where does that magistrate's opinion fall, right? So a magistrate, he has an opinion, but he is not empowered to do anything per the JJ. He is not within the ambit of the JJ Act, the JJ Act's authorities that are created. He is not in the Juvenile Justice Board or whatever. What should he do? Section 9 elaborates upon it. It states that where a magistrate has an opinion, such as he knows that the child, there is a child who has committed a crime, right? A child is in, we can call him a child in conflict with law. What will he do? He will write down or record his opinion, and he will forward the same to the relevant Juvenile Justice Board, right? So the Juvenile Justice Board that has jurisdiction of this particular child, the magistrate here. So Section 9 creates, and it creates kind of a portal for external advice, right? For external advice and external influence, not influence, but external advice and help from magistrates. If they have an opinion, they can lend that opinion to the JJ board. So it's not really shutting off all the procedures of the juvenile justice system from the external system. If it is an opinion of a magistrate who finds something to be good or finds something to be applicable and well established in law, he can write that down and forward it to the Juvenile Justice Board. This is also a question that quite frequently occurs. The options may be like the magistrate has no power, is not entitled, so he may not do anything. The magistrate has a power specifically written down, so he may, make judgment on the case. No, that is also not the correct option. There can be another option, that is the magistrate may write down and forward to the juvenile justice board. So you'll check that. Why? Because of section number 9. Next, we move on to chapter 4. That was chapter 3. Chapter 4 will tell us about the procedure to be adopted in respect with children in conflict with law. Are we all good to start with this chapter, or do we need to revisit anything? There are any issues with anything so far? Yes, guys, just let me know in the comments. I'm at the comments right now. A little feedback would go a long way. So please let me know. All right, then I'll move on to chapter 4, as I was saying. So, there is a procedure for children in conflict with law. There are specific procedures. We know that the JJ Act deals with them, but where specifically? This happens in chapter number 4, right? So, first we deal with the procedure of apprehension of child who is alleged to be in conflict with law. How do you apprehend this child? How do you get a hold of this child? Section 10 begins to talk about it. Section 10 tells us the foremost duty of the police officer, who will now be called a person in charge of the special juvenile police unit or a child welfare police officer, is to place the police officer, whoever gets a hold of him, his duty is to place the child with the special juvenile police unit. So he won't be held in a normal jail, in an adult jail, not in a normal lockup. He has to be placed with this particular unit or a designated child welfare police officer, which we saw the definition of in section 2, right? And you are then, these authorities are then required to produce the child, just like we have a habeas corpus. The habeas corpus extends here as well, just with different authorities. Produce the child within 24 hours of apprehension to the nearest and relevant juvenile justice board. And even during this 24-hour period, you have to make sure the time for the journey has to be excluded. So you have to make sure you are working swiftly to produce the child before the JJ board and not cause the child any unnecessary harm or fear, right? Then this chapter also talks about the person's responsibilities who is in charge of a child in conflict with law. Then there are also provisions on bail, which are very important. So we'll be discussing the provisions on bail now. Moving on to section number 12, that deals with the provisions on bail. Basically, bail is a given to juveniles. Bail is given. So section number 12, that is section number 12 of the Act, provides that the provision of bail is open for children. So bail must be given. This has an overriding effect on the general bail provisions of CRPC, right? So if required, the child must be placed in the care and supervision of a bail officer, a probation officer, or any other fit person. So if a child, if it is a prima facie a child, a person is prima facie a child, the bail again will be given. It will be granted, right? But if the court, there might be instances, this does not mean that this is a hard and fast rule. There might be instances where if you grant a bail, you will bring the child in association with an unknown criminal. There is this risk, right? Sometimes there is this risk. Or you will expose the child to some harm, or you will defeat the end of justice in the long run. So, in that scenario, of course, the bail provision will not be exercised, the bail may not be given, right? So, now section 13 then goes on And what happens when the bail is not given because of these factors? Bail is not given, right? So you have to write down the reasons for not giving bail. You have to write down the circumstances for not giving bail. Then there is also the duty to inform the authorities. Duty of the authorities to inform the guardian or parent or probation officer or whoever. It is important to inform them. So this is enumerated in section number 30, to inform them. This is a duty on the child welfare police officer or the special juvenile police unit that we just dealt with, talked about. So the duty to inform all of these, or any of these, whoever is available, that the arrest, apprehension, etc., whatever has happened, has been made. Next, we move on to, in this very chapter, inquiry, preliminary assessment, and review, etc. Section 14 deals with the procedure of inquiry. So, you have a child in conflict with law, there is a particular procedure for inquiry. The procedure is such that you have to complete the inquiry process within 4 months from when the child was produced before the JJ board, right? And then an extension can happen, extension of this period. We see even in the police conducting the inquiry before it moves on to the magistrate, a extension is allowed. Similarly, here also a brief extension is allowed, but the extension of the period is after you analyze the situations, the circumstances of the case, and record the reasons in writing. You can give a 2 month extension. So, on the whole, this moves up 4 to 2, that is 6 months, but no longer than 6 months should the inquiry take place. Inquiry must be done and dusted, closed within 6 months. All clear up till now? Next, we have section number 16, review provisions. Like I told you, who has the power to review, right? So the power of reviewing the pendency of cases shall vest in the chief judicial magistrate or the chief metropolitan magistrate, right? And the review of the pending cases by these authorities is done every 3 months. Every 3 months, right? And the bodies review this and then accordingly tell the board to, whether the judicial magistrate or metropolitan magistrate thinks it's best to have the board increase its frequency of sittings, it will direct it to do so, or if it finds fit, it will tell the board to and help the board constitute additional juvenile justice boards to ease off the load. Then section number 17 deals with procedure for after conducting the inquiry. Now, we were talking about whatever happens in inquiry. What happens when an inquiry is conducted and the child is found to be not in conflict with law, right? So we were presuming the child to be innocent, and the child turned out to be innocent at the end of the day. What happens here? So here we can see, for example, inquiry is conducted. The board is of the opinion that the child did not commit the offense. The board will pass an order to that effect, right? Sorry. And then if the board thinks that it is required that the case move to the child welfare committee so that the child can be properly rehabilitated, because this whole inquiry process, no matter if the child was not in conflict with law, still the child went through a traumatic experience. He will still need rehabilitative measures. He is still a child in need of care and protection. So there are times that this might happen, and in this situation, the board will pass this on to the child welfare committee, right? Next, we move on to a very, very, very important provision, that is section number 18. All right, guys, section number 18, it deals with the powers of the board when the child is found to be in conflict with law. So, the opposite of what we just discussed in section number 17. What will the board do? Right? So, this will take a bit of time. Let's be very fresh and very clear. So, when the Juvenile Justice Board is satisfied by its inquiry that the child has committed an offense, whether it is serious or petty, is there can be two things, is under 16 years of age and has committed a heinous offense, or is above 16 years of age and has committed a heinous offense. Now, the board is, after its inquiry, convinced that the child has committed a petty or serious offense, or has, whether he's under or over 16, has committed a heinous offense. Then it does a, what happens next? It does a preliminary assessment to find out the nature of offense, to find out the supervision, what is required, who will supervise the case, who will intervene, what body will intervene, what are the circumstances, right? What is the past conduct of the child? What are the circumstances when the offense happened, right? Then what does the board do? There can be a variety of things that the board does. There can be a petty offense where the board may admonish and counsel the child, right? There's this lower end of the spectrum where the board may do this, counsel the parents, help the parents deal with the child and send the child home, right? Or direct the child to participate in some counseling, some similar activities, or order the child to perform community services, right? In the supervision of a specified person, or order the child or his parents to pay fine, etc., right? Or there can be a period of probation that is set upon the child, and the child is told to have good conduct within the period of probation, right? And then after the period of probation, can set the child out for good conduct. This can happen. Or where these heinous offenses come in, then the board can further decide who is to intervene, what body is to intervene, and what procedure we will adopt going on further, right? Because I told you the JJ board can, if it is above 16, if it is in 16 to 18, then if it is a heinous crime, the JJ board has a procedure where it can adopt stricter measures of dealing it. If it is a heinous crime, of course, that provision can be exercised. Section 19. It talks about the children's court. We talked about what a children's court is. A children's court is a body created under Section 19 by the state government, etc., etc. We talked about that in section number 2. So now the preliminary report, assessment report that we just talked about in Section 18 that the JJ board creates, per that, now the children's court will decide whether the child needs to be tried as an adult. Do we need to do that? This is what the board will decide, right? If we need to pass proper orders, what needs of the child we need to keep in mind, how will we keep them in mind, what atmosphere should we adopt in dealing with this trial, right? Or does the child need to be not tried as an adult, right? Does it need to be tried per the juvenile justice board orders, and in that atmosphere? So again, it's exploring how heinous the crime is actually over here, how serious the crime is, right? So that is the procedures for children in conflict with law that we have discussed up until now. Is everything clear up until now? How the whole commotion goes on, what the entire procedure is, where the case starts from, what the body's constitution is, the Juvenile Justice Board's constitution is, and how it helps. We saw the Justice Board constitution in the previous chapter. We saw how it helps in ascertaining the rights and the protection required of the JJ, the juveniles. Okay, yeah, Yash, which provision for heinous offences by child between 16 through 18? That's what I told. That's what I answered in the discretion of the children's court. So section 19 will kick in, and then the children's court will decide how to proceed with. Next, we will move on to chapter number 5, which talks about the Child Welfare Committee. Again, we talked about two ambits. If it's a child in conflict with law, it will go to the Juvenile Justice Board. If it is a child who requires protection, who's in need on protection of care, he will go to the Child Welfare Committee. Or we otherwise can just call it the committee, right? So it provides basic care, basic treatment, basic protection, development, and rehabilitation to all the children. As always, we'll start with the Constitution. Section 27 elaborates upon it. Again, it's done by the state government, and it's done for every district. It's responsible for taking care of children in need and of care and protection. So the government can constitute one or more of such committees by a notification in the official gazette, and the committee also has to make sure that the members that it has, they go through proper induction and training, because see, this is a very ground level, and they are tasked with very important things to make sure that the children feel safe, they have vocational activities, they are rehabilitated, so they need proper induction and training and sensitization, most of all, right? Not everyone will know how to deal with children in such specific vulnerable positions, so sensitization and induction and training must be done within 2 months of the notification of such a CWC being created by the state government. Whenever it's notified in the official gazette, within 2 months of that, the body itself, the committee itself, must make sure these trainings are done. So, section 27, composition, right? We saw the composition of the Juvenile Justice Board. Let's move on to the composition of the Child Welfare Committee. The composition of the Child Welfare Committee is as such as that there is a chairperson, first of all. So, a chairperson. Then there are 4 other members, right? And again, one is a woman, and one is an expert in child matters. So one is a woman and one is an expert in child matters. And then a district child protection unit is to provide a secretary and other staff if required. So that is another end of the CWC or the committee. Now, what is the experience required for these members? The experience required, again, kind of similar to the Juvenile Justice Board experience. So, you must, as a person who is interested to become a member here, you must have a degree in either psychiatry, child psychology, sociology, education, human health, uh, and human health and development, or special education for differently abled children. Plus, you must be involved. So, this was one ambit. You can satisfy any of these. But in addition to this, you will have to satisfy your involvement in education, health, law, social work, welfare for 7 years. So, again, it was 7 years for the JAJ board as well. Or you must be currently a practicing professional with a degree. That means a practicing professional in any of these fields with a degree in any of these, right? So that is the brief composition and requirement of who you must be in the committee. Next, we will deal with tenure and termination. The tenure is that your tenure will only go up to 3 months, 3 years. So a member of the committee can only stay 3 years. So you cannot be appointed any further of 3 years in the committee. So 3 years maximum for members. Termination, again, like in the juvenile board, happens by inquiry by the state government, and again the same grounds. If you are found to be misusing the power that is vested under this act upon you, you will be terminated. If you fail to consecutively sit in the meetings for 3 months without notice, if you fail to attend at least 3/4 of the sittings, or you've been convicted of moral turpitude offenses, etc., those things will render you terminated from the committee. Then there is also a role of the within section 27 itself is elaborated upon through sections 27, 8, 9, 10. The role of the district magistrate is talked about. As we know, the committee is a body that operates at the district level, right? So the child welfare committee, the committee is to submit its reports to the district magistrate after conducting quarterly review of the functioning of the committee, right? And the committee itself, an important thing, it acts as a bench, right? Because it has so many members, it acts as a bench, and it is given by JJ Act the same powers as are conferred upon a metropolitan magistrate or a judicial magistrate of first class. So for these matters that it is dealing with, it is given the same powers. Then the where do the cases go from the CWC? What is the significance of the district magistrate here? Like I said, we are dealing with 8, 9, and 10 of section 27. So the district magistrate acts as a redressal authority. If there is any grievance arising from the working of CWC, it goes to the district magistrate, right? And a complaint can be dropped at the district magistrate. He takes cognizance and takes up the hearings of the parties, and then appropriately passes the orders. Now, important section, section number 28, which deals with what happens when there is a difference of opinions. Simply, majority prevails. And in case of no majority, the chairperson's opinion prevails. Right? Next, like we saw the powers and responsibilities of the JJ board, we have to see the powers and responsibilities of the committee here, which are enumerated in section number 29. Basically, it has twofold powers. Section 29, the first power is to dispose cases. Of course, we have to remember these are all cases not for children in conflict with law, but children in need of protection and care. So if there are care based cases, basic needs need to be met, treatment, protection, development, and rehabilitation, it needs to dispose of these cases and properly give everyone what is due as their right. Then it also, apart from that, has exclusive power to deal with these cases. Okay, so the CWC is the exclusive body that deals with providing care and protection. Right, so it has the exclusive power to deal with and dispose of these cases. This is enumerated in section number 29. Right, so that was the CWC. We saw the Juvenile Justice Board chapter. We saw the chapter on procedure for children in conflict with law. Now we have talked about the Child Welfare Committee. Now we will talk about the procedure for children who are in need of care and protection. So we understood how the board works and how the board helps to realize the procedure for these. We have now understood how the CWC works, and now we will understand how the CWC works to aid the procedure in respect of children who need this care and protection. Now we will move on to chapter number 6, which talks about procedure for children in need of care and protection. procedure for children in need of care and protection. All right. So I'll just give you a basic rundown. Since this is a rapid revision, we cannot go in way too much detail. So the first thing that happens is the child, of course, is produced before the Child Welfare Committee. This is dealt with under Section 31. Let's remember that. Then the case must be mandatorily reported. If the child is abandoned or lost, this is Section 32. And if you do fail to report this, if there is a non-reporting of an abandoned or lost child, Section 33 creates an offense for this, right? It categorizes such non-reporting as an offense, and the penalty is provided for this in Section 34, which is imprisonment up to 6 months or 10,000 rupee fine or both. Okay. Then after this, you can deal with the child however the CWC deems fit, and then the child is surrendered. Sorry, the child can either be lost or abandoned, or the child can be surrendered, right? Just like we talked about the relinquishment of a child earlier on, how a child is relinquished before the Child Welfare Committee. So the surrendered child, of course, the relinquished child by a parent or guardian, because they are no longer capable of taking care of the child, they relinquish or surrender the child to the CWC, and that is dealt with under section number 35. Now, in both of these cases, whether the child is abandoned or lost, or whether the child is surrendered, so section 32 or section 35, what happens? An inquiry takes place, or a special investigation or a social investigation takes place. And this happens within 15 days of first receiving it. This is section 36. Section 36 talks about this, okay? So I'll erase a bit of this so that we can move further than section 36. So section 36 talks about this inquiry. And from the findings of this inquiry, the committee then creates under section 37, it creates its orders, right, and passes them. Then under section 38, the court examines everything and sees what happens to the child. So either the court can declare the child to be free for adoption, right? Or if the child was abandoned or lost, it can check whether the parents are fit to take care of the child or not, and hand over the child again, right? So we talked about section 32, right? Section 32, this was the basic rundown. Now 32, 36, and a few other bits we'll discuss just in a tiny bit of detail, starting with 32. So 32 here was about abandoned children. So if there is an individual or a police officer or any other person who is in a hospital, maternity, nursing, whatever, if they find or take charge of a child who is abandoned, orphaned, or they find them lost, right? You know when a child is lost, you know when a child is abandoned or orphaned, you can tell. So if you find such a child, then first is to, like I said, mandatory information. You have to give information of such child. And this must be done within 24 hours, again excluding traveling time. Who must you give it to? It must be given to the Childline Services. This can also be a question in your prelims. Who must this information be given to? So you can give it to Childline Services, you can give it to the CWC, you can give it to the nearest police station, whatever is most possible at that point of time. You can give it to the district child protection unit, the district CPU, or you can give it to the nearest child care institution, right? So these are the authorities where you can submit this information. Okay. Then we talked about 36, where the inquiry is completed, the inquiry that the CWC does in the case. So, what happens after the completion of the inquiry? Here, the committee can find out many things can happen. It is possible that the committee finds out that the abandoned child has no family, or the abandoned child has family but he has no ostensible or reliable support, or he is still in continued, even after we dealt with the case, the child is still in continued need of care and protection, right? So the committee can, after the inquiry, make any of these findings. It can be finding number one, two, or three. What does the committee do? The committee may send the child to a specialized adoption agency where where the child is under 6 years of age, and otherwise where he is above 6 years of age, the child may be sent to a children's home, a fit facility that they may deem something as a fit facility that is under the ambit of the powers of the committee, or a foster family. Now, on paper, all of these things are continuously monitored by the CWC. So, the CWC will be in a better position to observe how the child is doing. So, these two things can be done. So, this will be done till a more suitable arrangement is found, rehabilitation is found, or till the child attains 18 years of age, where the child now becomes an adult and they can fend for themselves, they can find employment, etc. Meanwhile, the entire committee and the entire agencies under the JJ Act are providing him support, vocational training, etc., and making sure he's capable of finding employment at 18 years old. So once he's 18, he then does not have to be subjected to any of these institutions or any of these foster cares, and he can fend for himself. Okay, so that was the procedure on how children in need of protection and care shall be dealt with. Are we clear to move on to chapter number 7, which deals with rehabilitation and social integration? Yes, guys. Like I said, the Child Welfare Committee, Yash, is created, constituted by the state government. Uh, we dealt with this in the constitution portion of the CWC 2 chapters ago, right? So we'll be moving on to chapter number 7 now. So we know that all of these provisions, whether you are a child in conflict, you are dealing with a child in conflict with law, or a child who requires care and protection, there are immediate measures you go to, which were the measures we discussed so far. But what happens after all of these measures have been gone through, after all of these procedures have been followed? You need to make sure you are rehabilitating and reintegrating. Again, we move on to the final few purposes of the act. We first moved on to identifying who is a child in conflict with law, who is a child in care of protection. We moved on to then the purpose of the law, where it is to provide such care, protection, or to tend to that child in conflict with law. And whenever all of that is done, then the purpose of rehabilitating and socially reintegrating that child kicks in. Now we are in that phase. This is dealt with in chapter number 7. So the institutions that are created, basically, like I told you before, child in conflict with law, juvenile justice board will handle that. Child in need of care and protection, the CWC will handle that, right? Sometimes the case where the child is in conflict with law is found, like we discussed, is found not to be in conflict with law, the child may be directed to the CWC. So the two work hand in hand. There's not a sharp divide between the two. The two work hand in hand in realizing the aim of the JJ Act 2015. So the basic categorization here that we can make is that children in conflict with law, these are the institutions relevant for them. Observation homes, because they need to be observed because they're in conflict with law, right? Special homes, again, this is the exact destigmatizing semantics I was talking about, right? So these are not stigmatizing, it's just observation home instead of a penitentiary or a jail. Special homes, place of safety. So these are the terms and these are the institutions used for children in conflict with law. Now we come to the other side, children in need of care and protection. For them, we have child care institutions, specialized, we just talked about it, adoption agency, open shelter, fit facility, or the handover can be made to a fit person, which the court determines, the committee determines. Okay. These are the basic institutions involved in realizing Chapter 7, that is rehabilitation and social reintegration of a child. Okay. Now, let's see what the Act specifically in Chapter 7 has to say about the procedure for socially reintegrating and rehabilitating children or juveniles. The Act states, and we go to section 39, it states that rehabilitation and social reintegration, it is not just a broad blanket based strategy that you can apply. It has to be done in what is known as a individual care plan basis. Every child is different. Every child's social scenario, every child's scenario, especially when you're dealing with juveniles who are in these unforeseen circumstances, their scenarios are vastly different and they will require individualized care that is best suited to their specific needs and wants, right? So they will require an individualized care plan. They will require placements. If it's a child in conflict with law, right, they will require placements of that sort. If it is a child in need of care and protection, they will require placements of that sort. Then they will require financial support when they turn 18, right? When they are about to turn 18, that is the transition between 17 and 18, they will require financial support so that they can leave the institution, they can leave the care institution and get back on their feet and be reintegrated into the society. So these institutions that are created, these child care institutions that are created and recognized by the government, first of all, they must all, childcare institutions, they must all be registered so that the JJ, not the JJ board, but the Child Welfare Committee can keep an eye on it. They can keep it regulated and it is, documented and booked in the government's books. So it has to be registered, right? Section 40 mandates the registration, right? And there are also provisions in there for penalty of non-registration. If you are a childcare institution and you're not registering yourself with the government, there is a penalty. And when these children are placed in care institutions, in order to realize the aims of Chapter 7, right, the reintegration and rehabilitation, how does the reintegration and rehabilitation happen if you're a care institution? What must you bear in mind? You must bear in mind that you have to restore and protect a child that is brought before you, right? So whether you are a children's home, a special ed adoption agency, an open shelter, right? And you have to restore that child. So all of these things should be at the core. You should determine the suitability of the plan. You should adopt an individual care-based plan, right? So, like we said, the child care institutions must be registered. Section 41, sorry, not 40. Section 41 states that it must be registered. It has to comply. And if it is not registering, the penalty I mentioned is up to 1 year of imprisonment, and or up to and or at least not up to and or at least 1 lakh rupees in fine. Okay. Then open shelters, as mentioned, section 43 deals with open shelters where children can be kept, uh, but who, like we talked about, children in conflict with law. Open No, sorry, children who need care and protection, they of course also should be registered in the same manner. So these work as community based facility for children who need just residence, right? Residence. It's a short term safety measure to protect them from abuse, to protect them from leading a life on the streets, right? To keep them safe. So of course these institutions, they also need to provide reports, etc., and send them to the district child protection services or the district child protection unit and the CWC, the committee, of course, right? And then section 44 deals with where and when children can be placed under foster care by the committee. So this is not just individual foster care, but sometimes it allows the children to be placed in group foster care. Of course, this will be per the orders of the CWC. If the CWC examines the child's case and finds it best that the child be placed in foster care, it can be done. We just a few when we were discussing the CWC's functioning, we saw that the CWC can come to an array of conclusions, and one of the conclusions was to place the child in foster care. One of the conclusions was to give the child away in adoption, right? So we know what a foster care looks like. Again, the sections relevant here are basically 37, 1, 44, right? And within it, there are various sections that deal with, for example, the CWC will select the foster family per section 44. It will declare who is a fit person for foster care in 37 2. It will make orders for placement. For example, how will the siblings be kept? Will the siblings be kept apart? If there is a parent, for example, a child is surrendered and there is a parent, will the parent be allowed to visit? So stuff like that is in 44. And again, follow-ups, etc., by the CWC and its representatives, again in 44. And then there is also another thing known as sponsorship. So this helps with the financial bit and the sustenance bit. So section 2 in 58 also defines sponsorship as supplementary support to the child, right? So again, section 45 here of chapter 7, it allows the state government to make rules for sponsorship and create programs for sponsorship of children. You must have also come across social activists promoting sponsorship programs, sponsor a child, sponsor a child. So that is another example of this. A state government allows those programs to be. It can be an individual sponsorship, it can be a group sponsorship, a community sponsorship, right? Then section 46 deals with giving financial support. The one we talked about, financial support when a child requires reintegration into society, right? So you give financial support, the government allows financial support under 46. And there is the concept of aftercare organizations, so that you are not it would defeat the purpose of the JJ Act to keep the juveniles in a contained atmosphere, and once they turn 18 just throw them out on the street. It would defeat the very um, fabric of the JJ Act. So the aftercare organizations come in, where the children are taught vocational training, therapeutic training, education, continuing education, so skills that can turn into breadwinning tendencies tomorrow, social values, economic ability, all of that, right? And we did talk about observation homes for the children in conflict with law. Children, so this was all about children in care, need of care and protection. For children in conflict with law, Section 47 deals with establishment of observation homes. And then Section 54 is kind of important because it allows for procedure or process of inspection, which are of organizations or institutions recognized under the JJ Act. So all these organizations, shelters, homes, they can be inspected. Um, and then the inspection communities can be appointed by the state government so that they can inspect any of these agencies at any time, right? So that was the broad procedure for children or juveniles here per the JJ Act. We are moving on to now chapter 8 that deals with adoption, specifically adoption route taken for children who have no one to take care of them or who have someone to who should be able to take care of them, but the children are unfortunately surrendered or relinquished, right? So any questions at this point? I'm refreshing the chat just a bit. Any questions so far? We'll be dealing with adoption. Up next, not a lot of sections here, just general ideas on how adoption happens within this within the country, inter-country, etc., and the broad provisions for it. Yes, guys. All right, I see no comments presently, so I'll be moving on. So adoption, right? So in the ambit of JJ Act, what is adoption? What can be understood by adoption under the JJ Act, right? See, the word adopt comes from a Latin word meaning adoptere, which means to choose. So you get a person adopting a child gets to choose a child. But for the purpose of JJ Act, it is the act of placing a child, right? Act of placing a child with persons, parents other than the biological parents. Placing a child with someone other than the biological parents, right? So if we see section 2.2 of the JJ Act, this is what we can understand. Section 2.2 says an adopted child is permanently separated from biological parents or guardians, right? And then upon adoption, the effect of adoption is such that upon adoption, the child becomes the lawful child of the adoptive parents. And by becoming a lawful child, what happens? He acquires, not adopts, he acquires the rights, privileges, as well as the responsibilities as would be of a biological child. All right. So that is the aspect and the backdrop of adoption with respect to the JJ Act. So whenever the option of adoption is exercised by the welfare committee, this is what happens. The child is placed in someone's hands who is not the biological parent and then becomes the lawful parent and thus has to extend the same rights, the same obligations, the same privileges as that person would with their biological child. So if we look at the basis of adoption any further, section 56 makes certain points. So section 56 talks about what kind of children can be adopted under the JJ Act. It gives us three categories of children who can be adopted. It states that orphaned, abandoned, and surrendered. There's a very fine line between abandoned and surrendered children. Abandoned children are just left, and surrendered at least given over to the child welfare committee. But abandoned are just left out cold, right? And orphaned, the children lose their parents, right? Um, so abandoned, orphaned, and surrendered can go from being children with parents to becoming up for adoption, unfortunately. And then adoption may happen from one relative to another. That is also permissible per the JJ Act, right? And another aspect that 2056 elaborates on is the non applicability of these provisions, the JJ provisions on adoption, over the Hindu Adoption and Maintenance Act. So the JJ Act will not have an overriding effect on the Hindu Adoption and Maintenance Act. A child, a parent that is Hindu and wants to make a Hindu adoption, right, per the HAMA rules, the HAMA rules will follow. This won't have an overriding adoption application, right? And then it also allows for inter-country adoptions, the JJ Act. Okay, adoption is not really tested way too much, but sometimes it is. So, just a general perspective of how it happens and is supposed to happen under the JJ Act is necessary if we are to study it. So, the provisions for adoption must be followed in the JJ Act. A child is given over. The provisions for adoption must be and have to be followed. And if they are not, the punishment is mentioned in section number 80, right? So, if you take or send a child to a foreign country, this is inter-country adoptions, right? And it is done without an order, a valid order of district magistrate, you become liable for punishment under section 80. Or even if you only take part in arranging the transfer, okay, and custody of a child to a person in a foreign country, and this taking part you do without a valid order of the district magistrate, again you become liable for punishment in section number 80. All right, so that we must bear in mind that inter-country adoptions are to be taken seriously per the JJ Act here. Now, the eligibility criteria for who can adopt a child, right? The eligibility criteria is discussed in 57, right? So basically, there are certain very obvious eligibility criteria. You need to be physically fit, financially sound, and highly motivated to adopt a child. That is one. If you're a couple, both the spouses need to be willing to take the child in adoption. Single or divorced people are also allowed to take a child in adoption if they fulfill the requirements. That is, if they are physically fit, financially sound, and of willing nature to take the child in adoption. Again, a single male cannot adopt a girl child, right? And other requirements as may be made in the regulations to the JJ Act must also be fulfilled by the people who are adopting. Now, there are specific requirements for specific procedures for what is known as domestic adoption that are defined in 58. There are specific provisions for inter-country adoption, that is 59, and then there are specific provisions for inter-country relative adoption, that is in section number 60, right? And those I won't go in detail, but I'll just mention them here. Section 58 deals with your domestic adoption provisions. Section 9 deals with your inter-country adoption, and then your section 60 deals with inter-country relative adoption. Okay, so just so that if the questions about these sections come up, you'll know. And also, like I told you, the effect of adoption, the people who adopt become legal lawful parents, the child becomes a lawful child, that is discussed in section number 63. The effects of adoption, the adoptive parents become the parents of the child for all purposes, right? Adoptive child becomes the child of the adoptive parents, and this happens on the date on which adoption takes effect. And then, of course, there is the provision on mandatory reporting of adoption. If an adoption is successfully made, it needs to be reported, section 64, right? And the orders, etc., that the district magistrate, of course, the district magistrate is in the loop for allowing adoptions. The orders, etc., need to be communicated to an authority known as the KARA. We'll read about this a bit more further on a monthly basis. So this helps the authority table and create a repository on adoptions, because there needs to be a legal chart somewhere of how many children are adopted for the repercussions tomorrow. And then section 65 in this chapter also allows for specialized adoption agency, right? So the KARA is a central level authority for regulating adoption related processes, and this is the specialized adoption agency is a state level body for regulating processes of adoption, etc. And then section 67 also establishes another authority, which is the State Adoption Resource Agency, right? And this is set up by the state government for further, aiding the KARA, the Central Adoption Resource Authority's measures, and making sure that the regulations, etc., are taken care of, such as they are promoting adoptions wherever possible and facilitating adoptions, regulating adoptions, creating regulations that are required, carrying out all the functions that are highlighted by the regulations, right? Then there is also a question that might come in, that is section number 69, dealing with a steering committee. Steering committee basically is part of these authorities only in adoption authorities. So let me talk just a bit about it. It is the steering committee. This provision gets overlooked a lot of authority. This is part of the KARA only, right? So what it does is it decides on the priority of cases, priority of or order of business of the cases. So it takes the operations and decides the operations priority. It helps in adoption of rules, it helps in smooth functioning, it helps in financial budget allocation, etc., and keeps a view on the overall working of the KARA. And the composition is, there is an adoptive parent, right? Adoptive parent, and also an adult person who is an adoptee, right? So that both perspectives are counted. There is a member secretary. Maybe this question comes in, right? There is a State Adoption Resource Agency, the SARA agency member. There are two specialized adoption agency members, two SAA. There is an ex officio member. You have an advocate present there. There are two ex officio members actually. One is from the joint secretary. One is a joint secretary of the Ministry of Women and Child Development, right? and one is the joint secretary of Ministry of Women and Child Development who deals with finance. The other deals with the Kara cases, right? So two ex officio members. And then, of course, there is the ex officio chairperson. These were ex officio members, ex officio chairperson, who is the secretary. These are the joint secretaries. Secretary to Ministry of Women and Child Development of Government of India, right? So the adoptive parent, adoptee, member secretary, who will be the CEO of the organization, one member of state adoption resource agency, two specialized adoption agency members, two ex officio members who are joint secretaries of Minister of Women and Child Development, one who is a finance dealing member, one who is a member dealing with Kara, one advocate or professor who has 10-year experience with family law, and this is the general steering committee. I don't know why I suspect this might be a question. I have a feeling. So what is this steering committee constituted of under JJ? Sometimes they ask very off questions. So are we all clear to move on to the second last chapter, that is offenses, other offenses relating to children? That is chapter 9. Can we move on to chapter 9? All right. So, chapter 9, we begin with section number 74, right? Where there is protection of privacy of juveniles, and I'll tell you how. So, it prohibits modes of communication, popular modes of communication, and prohibits the disclosure of sensitive information with respect to whether it is child in conflict with law or child in need of care and protection, except where is required for the inquiry. So anything outside of inquiry where the child is documented, and is made subject to modes of communication, that is prohibited. Why? Because that might run the risk of leaking information, damaging the child's reputation in the society, right? So, if anyone fails to observe this, 74.3 provides a punishment. So, imprisonment up to 6 months and fine up to and or fine up to 2 lakhs, right? So, that is another offense. If you fail to protect the privacy of a child, this is an offense you will be committing. So that is enumerated in chapter number 9 of JJA. Let's move on to 75. 75 talks about the punishment that can be imposed on a person who is assaulting, abandoning, exposing, or willfully neglecting a child and harming them because of it, right? And of this, there are categories of if someone is in actual control of the child, or if someone is someone is otherwise doing it. If it is someone who's in actual control of the child, the punishment extends up to 3 years, and fine is 1 lakh, up to 1 lakh. It's and or situation, so either of those or both. So 76 deals with the offense of using a child for begging purposes. And it is important that when you're dealing with a child, this is not a child in conflict with law. No, this is simply a child in need of care and protection, because the child himself did not do anything wrong. He was used for begging purposes here. So if you're employing a child for this, the imprisonment provided is 5 years, up to 5 years, and fine. So not and or, you have to do both, and fine up to 1 lakh. And if for this, which we see often, the children are made amputees, right? But the children are hurt and maimed, then the punishment is rigorous imprisonment up to from 7 to 10 years, plus fine up to 5 lakhs for the person committing it. And it goes to the extent of also punishing a person who is in actual control of the child and is allowing for this to happen. For that person, the punishment is 5 years, up to imprisonment of 5 years, and then the same. Then we move on to section number 77. Which involves the offense of giving a child any narcotic drug, psychotropic substance, tobacco, or intoxicating liquor, which which subjects you to the punishment of rigorous imprisonment up to 7 years and fine up to 1 lakh rupees. 78. Smuggling, using a child for smuggling or supplying some substance that is controlled or not allowed. Again, same punishment up to 1 lakh, rigorous imprisonment up to 7 years. And then you have 79, where you're using a child to employ him and then using that employment earnings for your own benefit. So by employment you can make the child sell goods, services, or by employment you can also subject the child to entertainment business, right, for in public places, and you want the economic gain for your own self. So you're ostensibly engaging the child, you are keeping the child in bondage because you're taking the earnings away and holding them for your own purpose. Here, the punishment will be rigorous imprisonment up to 5 years. So, a drop down of 2 years from the above punishment. And again, the same here, 1 lakh. Um, and as we discussed the adoption provisions, this is a punishment for adopting a child without following the procedure. So the imprisonment will be up to either imprisonment, simple or rigorous, up to 3 years, or it will be a punishment, a financial punishment of rupees 1 lakh, or both. Right? So then there is the offense of procuring a child for any purpose, sale of child or procurement of child for any purpose, which is in section 81. Right? And if you're buying or selling a child, the punishment is rigorous imprisonment up to 5 years and 1 lakh fine. And if you are a person in actual control and you're doing this activity, then your punishment is imprisonment between 3 to 7 years. Then we did talk about corporal punishment. 82 provides for the punishment to it for exercising corporal punishment on a child in view of disciplining him. So if you're a person in charge, if you're in a childcare institution, if you do it for the first time, it's a first conviction of you indulging in corporal punishment, it's a fine of 10,000. And if it is a second conviction, you can get imprisonment up to 3 months and or 10,000 rupees in fine. Right? If you are a person employed in a child care institution, right, you shall also be liable for dismissal. So in addition to this, dismissal, or you can be debarred from work where children are allowed. So you can be debarred from working directly with children. Just a moment, there's up on the screen. All right. So we must pay special attention now to Section 84 of JJA, which takes into account sections 359 through 369 of IPC. Right? So these, by application of 84 of JJA, apply to children and minors. Right? We know that in IPC the age should be 16 for female, 18 for male. But here in JJ, any child under 18 who has been kidnapped shall be protected under 84. Otherwise, 359, 369 apply mutatis mutandis as they are to the provisions, to the kidnapping, etc. of children, right? But the only change made is that from this, it goes to this. And then we have section 88, alternate punishment. So if there is a case where two punishments are given by law, one law gives one punishment, one law gives another, or one section gives one punishment, the other gives another section, the one with greater punishment prevails. This is also frequently asked. Section 88 provides alternate punishment where there are two punishments available. The one with greater punishment prevails. Now we will move on to chapter 10, which deals with transfer and release of children. So transfer of release of children, whether they are children in conflict with law or children in need of protection and care. So over here, section 97 deals with the provision that the children can be sent by authorities to parents or guardians, so transferred back after they are processed. And then, of course, if the person they are given to is unable to take care after they are given to them, the child is then again brought back to the institution where he was to begin with. So whether he was in a child care unit or institution or wherever, he is brought back there. Then, of course, there are several other provisions, such as 92, providing for placement of children in a place of medical treatment, 93, allowing for the transfer of a child to a mental institution where the child is mentally ill or suffers from addiction, so an appropriate de-addiction center. Section 95, which allows for the transfer of a child, so this is for medical. 95 allows for the transfer of a child to place of residence, so he can be back home and reintegrate properly. 96, transfer of a child within the state itself, right? And then you have 97 etc., which deal with releasing a child from a child care institution, or 97 where you can temporarily release the child and check how they are doing and then they are brought back, so kind of on the same provisions that a bail operates, right? So that was 9. And now we move on to the miscellaneous provisions. There are a few miscellaneous provisions, and the miscellaneous provisions only I did test a few in the JJ Act mock. So this is one of them. Section number 91. Section number 91 allows for dispensing of attendance of child. So if the board or the committee decides that for the purpose of the inquiry, there is a situation such that where the child's attendance is excusable, right? The child's attendance is not necessary here, then it can dispense with the attendance of the child, and the inquiry will be conducted in the absence of the child, right? So the child's attendance generally is absolutely required at the time of recording statement, right? So that is a crucial point when the attendance is required. Otherwise, it can be the board or the committee will decide, and they can and may allow for the dispensing of the attendance. Then we deal with 94 sections 94 etc., where there is determination of age. The boards determine age because this is an important factor when you are dealing with such fragile provisions. You need to make sure that the person you are treating is in fact a child, and a month's difference child can make the difference between a child, a juvenile, and a full-blown adult. So the determination of age is a crucial aspect. So certain things, certain documents are required. So the most reliance is placed on DOP certificate from the school, or a matriculation certificate is equivalent to it. If both are unavailable, you can have reliance placed on a DOP certificate by a corporation, the municipality, etc. If neither are available, neither one nor option two, then ossification test is done, which is done with the help of chemicals, you know, and done on your bones, etc., and other tests that determine your medical age. Your teeth are checked. There's a variety of ways in which this is done medically. So, an ossification test is the last resort. Then, another miscellaneous provision is section number 99. That is again for privacy, right? So the records, etc., everything that is associated with the case with the juvenile must be kept, protected, and hidden, right? It is treated as absolutely confidential. However, the board may communicate it from one board to another board for purposes which are necessary, or the committee, the CWC, may communicate it from one committee to the other committee, right? And again, the parents, the guardians, the victim himself gets access to all of the resources, all of the documents, etc. They're not kept in the dark. So 100 is kind of a savings clause because it protects the central government, the state government officers from acting under the directions of in respect of anything done under this act in good faith, right? Under the rules and regulations of this act, section 100 deals with that. Then we move on to the very important aspect of appeals. Where do the appeals go? Which is discussed under 101. Right? So now, who can prefer an appeal? Any aggrieved person. And who can an appeal be preferred against? Board, committee, both. And what is the date? It must be done within 30 days from the date of the order, right? So if it is generally, you can go to the what is known as the children's court for all appeals, or if it is a case of foster care or sponsorship, like we discussed, sponsorship, aftercare, etc., you go to the district magistrate, right? And even if these 30 days expire, by the way, if the district magistrate is satisfied, the court of sessions is satisfied, in absence of district magistrate, the children's court, the district magistrate is satisfied, they can entertain it well beyond 30 days. But then it should be um, after those 30 days, it should be decided in the next 30 days, right? let's discuss this a bit more. This was the general overview of appeals. Let's go to 101 subsection 2. 101 subsection 2 deals with appeals against the order of the board. So an aggrieved person may go after the board's order that it made after preliminary assessment under section 15, as we saw, and it may go to the Court of Sessions. Right? However, 1013 and 1014 provide that an appeal shall not lie from any order of acquittal. Made by whom? Made by the board regarding a child who is made by the board regarding a child in case who is alleged to have committed a heinous offense and the child is above 16 years of age. Okay. Then 1016 deals with appeal against the order of the district magistrate himself. So now the district magistrate gives an order. What happens? Where does the appeal go any further from there? 1016, right? It goes from district magistrate to divisional commissioner, again within 30 days from the order of the district magistrate. And then we have revision provisions, which are in section 102. And the revision provisions belong to the High Court. The High Court can revise the case either on its own or by an application that it receives in this behalf. It can call for the records of a proceeding of the committee or of the board or of the children's court, and then it can revise this with proper procedures. So revisional powers with the High Court. We discuss the appeals, and then we have certain other bodies that are created, such as the Juvenile Justice Fund, created by the state government, right, for enumerating contributions, subscriptions, etc., and protection agencies contained under section 106. They are called the State Child Protection Society and the District Child Protection Unit for states and districts, of course, and district one's made district wise and the state one made at the state level to head it, and of course both are made by the state government. Then section 107, finally, it imposes upon the state government, central and state government, duties to enforce the act properly, to make sure that publicity is given to the act so that people are aware of the act, to train all the officers, etc., involved, right? And then section 110 further allows the central government to make model rules, right? To make other rules and regulations to bring forward the purpose of this act and to embolden the purpose of this act and realize it. And 112 deals with the central government's power to remove difficulties and pass orders for it. And such orders, of course, go to the parliaments after they are made. So that was your JJ Act, basically, believe it or not. I hope you've had an illuminating session so far. And if there are any questions, any queries about what we have read so far, just make sure you leave them in the comment box. And if you happen to have missed the later parts of this session, you can circle back and leave them for me on the WhatsApp chat that we have, and I'll be sure to get to it. So thank you for your time and patience in this session. Make sure you're taking your mock tests regularly and preparing with full gusto, and you will succeed. And all the best for your further endeavors and for the examination. Thank you so much.